Thanks for checking out our video on changes to eviction and foreclosure proceedings here in Colorado as a result of the COVID-19 impact. My name is Jeremy Baker, founder of Baker Law Group. This video is part of our Legal Tips of the Week series, and I hope you find this informative. In response to the significant financial impact COVID-19 has had on our economy, in particular the stay-at-home mandates, Governor Jared Polis has instated several executive orders that have major ramifications on residential and commercial landlords and tenants. These, in effect, have been put in place to limit eviction and foreclosure actions. I will highlight certain sections of these three orders, Executive Order D 2020-12, D 2020-31, and D 2020-51, that I think both landlords and tenants should be particularly aware of as it relates to the evictions and foreclosure proceedings. On March 20th, Executive Order 12 went into effect. Essentially, Section 2A of this order directs the executive directors of the Department of Local Affairs, the Department of Labor and Employment, and the Department of Regulatory Agencies to work with property owners and landlords to look for ways to avoid evictions. Section 2B of the same order also orders the governor to direct the executive director of the Department of Public Safety to work with all sheriffs, mayors, and other local leaders to take similar formal actions with their law enforcement agencies to suspend residential eviction activity in the state unless such actions are necessary to protect public health and safety. Section 2F goes on to direct DORA to take steps to encourage banks, credit unions, and other financial institutions that are holding residential or commercial mortgages to halt foreclosures and related evictions. Note, in the order there is not a prohibition of a landlord from initiating an eviction action or for a lien holder to refrain from initiating a foreclosure action. On April 6th, Executive Order 31 went into effect. The primary effect was to extend Executive Order 12 to run through April 30th, 2020. Most recently, on April 30th, Executive Order 51 went into effect. This order amended the prior Order 31 and makes some pretty substantial changes to the prior orders. First, the order extended Executive Orders 12 and 31 for an additional 30 days. Second, it also added 9 additional provisions surrounding the foreclosure and eviction directives. I will highlight a few of the more significant provisions. Section L prohibits a landlord from filing or initiating an eviction based upon a tenant default. Moreover, Section M prohibits the removal or exclusion of a tenant from premises, and Section N prohibits execution or enforcement of a writ of restitution, possession judgment, or requiring a tenant to surrender or vacate residential premises. However, importantly, these sections do not apply to circumstances where a tenant poses an imminent and serious threat to another individual or causes significant damage to property. The order goes on to prohibit landlords from charging late fees or penalties for any breach of the terms of a lease or rental agreement due to non-payment. It also directs all landlords to notify tenants in writing of federal protections against evictions and foreclosures at each property, including those provided by the CARES Act. The order also directs DOLA, the Department of Labor and Employment, and DORA to work with property owners and landlords to create model repayment agreements that allow tenants additional time to repay rent. If you need help with an eviction or foreclosure related matter, give us a call. You can find links to the complete governor's orders referenced in this video, along with additional resources on our website at www.jbakerlawgroup.com or by clicking the link below.